Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming. And in this video, I'll answer a question that we get all the time, and that is, who gets it all if I die without a will or trust? Well, that's a great question. Now, let me get one popular misconception out of the way first, and that is, does the state inherit everything if you die without a will? And that answer is no. That does not happen. If you die without a will, the state of Texas does not get everything. So that's really, really good news. It's possible that the state could end up with your assets if your family takes no action for a long time. Eventually, your assets may escheat to the state of Texas, but that's going to take years, probably 7 years or more. But what happens more often if a person dies without a will is that it goes to your heirs at law. You know, a popular saying that we have in our office is, if you die without a will, the state of Texas has one for you. And so that heirs, the people who inherit in the absence of a law, is referenced as intestate succession. So if you want to look up the law, it's called intestate succession, and that's who are your heirs, who inherits if there's no valid will or trust. Now, I've got some links down below that will be really helpful for you in like charts and things like that lay out intestate succession, and that's who inherits everything. But let me give you a couple of the most common scenarios. And those most common scenarios are people who died married with children and people who died married without children. Okay, because all of this matters. Because it can get a little complicated, and it really depends on what assets you have and what family you have when you pass away. Okay, so now that we've talked about who's not inheriting if you pass away without a will, let's talk about who does inherit if you pass away without a will. Well, in our law office, we say if you don't have a will, the state of Texas has one for you. And what it's actually called in the code is intestate succession. Intestate means dying without a will. Succession means who gets it. And basically, all of your estate will go to your heirs. And that law dealing with intestate succession lays out who gets what if you die without a will. Now, I've included a really helpful chart in the information below because this is really complicated. Be forewarned, this is not straightforward. And frankly, for a lot of the people that we talk with, it's counterintuitive. They can't believe the state's default will because it's not what they would have thought in terms of who would be inheriting. So this is surprising to a lot of people. So anyway, your heirs are the people who inherit when there's no valid will or trust. So who gets what depends on two factors, and that is, what family do you have when you pass away, like what survivors are there, A, and then B, it's what assets do you have. Now, the type of assets can be broken down into 4 categories. So you've got community property, and community property is a married person's jointly held assets, okay? So that's community property. And then within community property, you have community property that's real estate and community property that's non-real estate. Now, if you're dealing with a single person, or if you're dealing with a married person who has assets other than community property, you have separate property that's real estate and separate property that's non-real estate. So those are the 4 categories, and who inherits depends on which category every particular asset is, because each relative will get a different part of each category of those assets. I know, I told you, it's confusing. So just to keep things simple in this video, I'll talk about the 2 most common situations, and then if you want to look in the chart below, you can read more about the other situations. But the 2 most common situations that we see in our law office are the person who died and was married and had children from that marriage and no children outside the marriage. And then the other situation is when the person was married when he died and had at least 1 child from outside the marriage. Okay, now who will inherit each one of those 4 categories of assets will depend on those 2 situations. So if we're dealing with a married person who died with children, but no children outside the marriage, all the children were from that marriage, well then the community property, both real estate and non-real estate, goes to the surviving spouse. So the surviving spouse, she gets it all on the community property. Now, if there were any separate real property, which is actually pretty rare, but if there were any separate property, if it were separate personal property, meaning separate non-real estate, then in that case, the kids get 2/3 of the separate personal property category, and then the spouse gets the other third. If we're dealing with separate property that's real estate, the kids get it all, subject to a 1/3 life estate to the surviving spouse. I told you this is confusing stuff, and it blows most people's mind, so it's really important that you get a will so that your family doesn't have to go through all this complicated mess. Okay, so now let's talk about the other situation where we have a surviving spouse and there was at least one child born outside the marriage. Well, in that case, it's even crazier, and almost nobody can believe that this is the law, but it is. So if you pass away in this scenario, the community property, meaning the marital assets of that estate, the deceased person's share do not go to the surviving spouse. I know, it's mind-blowing. In fact, the deceased person's half of the community property actually goes to his children, and the surviving wife merely retains her half of the joint marital property or community property. So that's mind-blowing to a lot of people. They cannot believe that the surviving spouse doesn't always just automatically inherit everything. And in fact, in this case, 100% of the deceased spouse's half goes to his children, not the surviving spouse. So that's mind-blowing to a lot of people. And then on the separate property, it's the same as before. In the other situation, the kids get 2/3 of the separate personal property. Surviving spouse gets 1/3. And then on the real estate side, the spouse gets only a 1/3 life estate of the separate real property, and the kids get the balance or the remainder of the separate real estate of the deceased spouse. So I know it's crazy, I know it's complicated, and so I think there's a couple of main takeaways here. One takeaway is, and I said this before, get a will or get a trust. If you're a living person and you're watching this video, go get a will, go get a trust, because these laws are crazy to so many people, and it's expensive to go through this process. The other moral of the story is, if you're a surviving person, go talk to a probate attorney. The law probably doesn't say what you think it says in terms of who's going to inherit what. So go get an attorney's help. Seek out an attorney that has a lot of probate experience. That's the type of lawyer that you're going to be looking for, is a probate attorney, to make sure that you're getting all the assets that you're entitled to. Because even the default laws are really confusing and complicated and mind-blowing. But then it gets even more complicated because maybe a surviving spouse has a family allowance, which is kind of like alimony. Again, it gets even more complicated, but go get an attorney so that way you know your rights are protected and you're getting what you're entitled to. So I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning and probate attorney, licensed to practice law both in Texas and in Wyoming.